fascinating. Absolutely. And what about the law attracted you to study it?
Thank you. I'm somebody who cannot stand people being cheated.
Okay.
And so what motivates me is to fight for the ordinary people who cannot fight for themselves. And it started right from my training college days. And so my friends who know me used to call me, I know my right. I'll just fight for anybody. If you're in the wrong, I'll come after you.
Yeah.
If you're right, I'll defend you. I don't know how, but it's still within my blood to always stand for the right thing to be done. And I insist that the right thing should be done. And that's motivating. It gives me satisfaction to give justice to those who cannot pay for it.
And it's very refreshing, because some say that to be a judge is a calling. And to be feeling that way all the way at a very young age, I guess it explains why you are here at the moment. But do judges have fun?
It's relative. Because by virtue of what we are supposed to be doing, you're not supposed to be mingling too much with a lot of people.
Okay.
For fear that the very people you are dealing with, you might be compromised. It's not necessarily that the person, because of your association, people may think, or there's a perception that, okay, if I have a case with two people have a case before me, and people see me being so free with the other or the relatives of the other. Although you may have a good mind, it doesn't sound right, because justice must be seen to be done. And to avoid that, it's better you keep yourself from, as much as possible, from the public, so that you don't compromise your neutrality.
And so it means that a chunk of your social life is sacrificed when you become a judge.
Yes, ours is a lonely path. I would say a lot of us. As soon as you become a judge, even your colleagues at the law school hardly call you again. You are alone, and your family members are the only people that you have. Very, very few people, church members in my case, are more or less my people. Thank you.
All right. Okay. So I'll stay off that for now. I'm sure Rosemary is counting my questions. All right. So let's get into the substance of our conversation this morning, which has to do with our jury system. Now, first of all, who is a juror?
Okay. A juror is one of 7 people that the Constitution allows to be part of a trial, which punishment involves either death or life imprisonment, or which punishment, which the law says is a first-degree felony.
Okay.
In which case, we have to try it by indictment. And if an offense, they say it's an offense triable by indictment, it means that we have to try that offense by jury or by assessors. But in this case, because we are talking more about jury, would advert our mind to the fact that a juror is one of 7 people, and the 7 people collectively, we call them jury.
Okay.
When they form a panel, we call them jury to try. And who are they? They are the ordinary people of the community within which a court sits for the trial of a particular matter. Say, if the High Court sits within this premises, within 4 miles radius, the people who live here are the people who the law allows to be selected to be part of the jury to try a particular matter that is before a court.
Okay, so that's you said a 4 miles radius.
Yes, that is what the law says.
Okay.
So that within the jurisdiction of the court, we are expected to form a jury that will try a particular case. Okay. The reason is that the community has certain values and certain belief system, so that if we go for the community within the area where the incident happened, they are likely to understand the facts of the case. And the jurors, because normally they are not lawyers, they are not lawyers or legal people, they are the community people, and they are supposed to be trial of facts.
Okay.
And listen to the evidence of the court and then come to a conclusion. The judge who sits with them also is in charge of the law. And so at the end of the day, we put the two together, and their verdict is what is binding on the court.
And why the number 7?
7 because they will vote after the trial. You know, I've said their decision is binding on the court, no matter how we look at it. That is what the law says. So they are supposed to vote if in the case of capital punishment, they all must vote, and we call it a unanimous decision.
Okay.
Unanimous decision means after the trial, looking at the facts, and when they compare it to the law that had been summed up for them, then they would have to return a verdict that this person, according to the evidence, in our opinion, is guilty, and all the 7 must agree. In the case where the punishment is life imprisonment or anything on indictable trial, offense on indictable trial, then it has to be by majority, and the majority has to be 6 against 5 or 2.
6 against 1?
6 against 1, and then 2 against 5.
Okay.
So that their decision, we don't have to have a split.
Okay.
If there are 6, how do we get the
yes, you don't get the balance. Okay. And so in the instance where you don't get either the 5-2 or the 6-1, what happens?
That is what we call hung jury. The hung jury is where, if the law says we must have majority 6-1 or 2-1, but majority, about 3 would say that we think he is guilty. 2 will say we think he's not guilty. That means we have not met the threshold.
Okay.
And the law says that when we get to that level, then we have to order for retrial. The jury that sat on that particular case, the law would let us dismiss them, form another jury, and then do the trial with a new panel altogether. And so when we don't get clear majority,
Starts afresh.
We start afresh.
That's a lot of work.
Really.
Oh dear. Imagine you have spent 3 years on a case and then you get a hung jury, meaning everything starts from scratch.
Yes, everything starts from scratch. We have to reinvent the wheel again.
Witnesses all over again.
All over again. Everything all over again.
And in the case where some witnesses have passed on?
That is the difficulty and challenge, and one of the reasons why we are doing the reforms to ensure that we don't delay too much on a particular trial, so that as soon as the case is brought, we do the hearing quickly enough,
expeditiously,
so that we don't lose the evidence.
All right. Thank you very much. I'd like to say a very good morning to Her Ladyship, Justice Serwah Asare-Botwe. She's also a Justice of the Court of Appeal. Good morning.
Good morning.
Oh, it was a struggle getting here.
Oh, yes, yes. Technology has failed us today.
You know, we've all become so reliant, such that when it disappears for a moment, then we are found wanting. I hope your morning has been good.
Not bad at all, thank you.
Fantastic, good to have you. And I was telling Her Ladyship as well that it's rare to have you all join us for a conversation, not 1 but 2. It tells you that the task at hand is huge, and so it's good to have you all here once again. And okay, so let me pick up from where we left off. Now, how important is the role of a jury in the delivery of criminal justice in Ghana?
The jurors are of utmost importance, each of them.
Okay.
Now, the reason why we say each of them is that without a quorum, it's not like having a quorum in a business meeting where you say, well, we are 6 out of 1, we can go on. In the case of a jury, if 1 juror is absent, it's enough to put a stop to the trial. All of them must be present.
At all costs?
At all times and at all costs. If only 1 is absent, if 1 dies, we have to start all over again. If one of them takes ill, goes to deliver and is unable to make it, we have to start all over again. So they are of utmost importance. Number 2, where the class of offense or crime is the kind that demands a jury trial, a summary trial will be held to be invalid, actually to be void. I have seen someone charged with rape placed before the court of summary jurisdiction because at that time the prosecutor was of the view that once a rape charge has a very specific punishment, 5 to 25 years, even as against defilement, which is 7 to 25, the prosecutor was of the view that they could do the trial summarily. The Court of Appeal held that once it has been said that rape is a first-degree felony and triable by judge and jury, even if the evidence is of such a nature as to convict, the whole trial was void.
Wow.
So you would have to do the trial again.
So once it is stated that this is a trial by jury, it has to be.
So manslaughter, murder, use of offensive weapon, that's somebody pours acid on somebody stabs another person, currency offenses, terrorism offenses.
So the currency in terms of printing fake
currency,
money.
yes, all those things are first degree felonies, triable on indictment. The jury must be present, and all of them at all times.
All of them at all times. Wow. And her ladyship mentioned that it has to be within, is it a 4-mile radius?
Jurisdictional, yes, there is a jurisdictional
district.
Okay, so must it always come from the accused in question's area?
No, we are looking at the jurisdiction of the court.
Of the court, okay.
Of the court where the offense was committed.
Okay.
Now remember that most offenses are tried within the region that they occur, unless we have exceptional circumstances like the Yana case. That one, it was tried in Accra. But generally, most offenses are tried within the jurisdiction where the offense took place. So in such an instance, the jurors must come from the 4-mile radius, which is about 8 to 10 kilometers radius of the High Court that the trial is taking place at.
I see. So if, for instance, a selection is done and it is out of that radius, it means it invalidates it.
It could invalidate it. So, for example, we can't have a juror from Koforidua coming to sit in Accra for a trial on indictment. No, it has to be within, not too far from here.
Okay.
So it is either the person lives within the jurisdiction or works within the jurisdiction.
Okay. But how do the roles of judges, prosecutors, private legal practitioners, which is the bar, legal aid, and the police collectively impact the fairness and efficiency of jury trials?
Let me deal with the efficiency, and my sister could deal with the fairness.
The fairness, okay.
You see, we are having stakeholders who all have to be present. In general, when you are dealing with first-degree felonies, they must be represented. In general. So either we have a private practitioner who has been recruited by the accused person himself, or a private practitioner who has been appointed by the court. Actually, when we are having criminal session, the judge may decide to appoint any lawyer to defend the accused person, because yes, we have legal aid, but legal aid, they don't have sufficient numbers. And I think now they even have a public defenders division of the legal aid authority, but they don't have enough numbers. So the court may, and then the prosecutors. The prosecutors are the ones who are supposed to produce the witnesses, produce the documents, and we are looking at it in quick succession. We no longer want these interminable trials. So each of the stakeholders must do their job. We are looking at, if an accused person is in custody, the police officer or prison officer who has custody of the accused person, producing them at the right time, coming in early enough, and then the jurors also being present. So if we have all of them, then we'll have an efficient system. If the judge is also making sure that he or she has firm control of the proceedings. We don't want situations where a lawyer shows up and says, my lady, I want an adjournment because today is my wife's birthday, or any of those ridiculous things that
excuses
people
or
can,
reasons, yeah.
think up. So for that, you need everyone to be efficient.
Okay.
Now, my sister, I'm sure, will
Talk about fairness.
Fairness, the Constitution 19:1 says a person charged with a criminal offense shall be given a fair hearing within a reasonable time by a court. And so the Constitution places an onus on us to give any person that has been charged and brought before the court a fair hearing. And what does fair hearing means? It means that the person is adequately represented. In any case, the law first and foremost sees that person to be innocent. Anybody that is hauled before the court and charged with a criminal offense is first and foremost seen as innocent of the until his offense is established by whoever claims he has committed an offense. So there's that presumption of innocence. How does the person get a fair hearing? The person gets a fair hearing by legal representation. If the person appears before the court and there is no lawyer because he cannot afford, the judge is obliged to appoint a lawyer for the person, either from legal aid or from the bar. The bar are the private practitioners. And also that there are certain documents, the charge, the facts, the evidence that is being brought before the court against the accused person. And we are obliged to produce every document to the accused person and his lawyer to have a fair knowledge of what kind of case that is being brought against him, to prepare adequately, because the Constitution also allows us to give the person time to prepare adequately for his defense. So if you are able to give all these to the person and the lawyers and the judges are ready, everybody, the accused person is brought to court on time, witnesses come on time as scheduled, then of course we are able to give a fair hearing to the person. It's not fair. Some of the facts that come before the court, when you look at it, you are not able to give the bail to the accused person for fear that the person might abscond. And so we are supposed to keep the person in custody. And it is also not fair under the Constitution to keep the person in custody in perpetuity. We have to, whilst in custody, give the person an expeditious trial. And so that is how we come by all this. So all hands on deck, everybody, witnesses are ready, the jurors are ready. I emphasize that if one person out of the jury does not show up, we can't work. The witnesses can be there, the accused person can be there, his lawyers can be there, the prosecutors can be there, the judge is also ready. But if one person out of the jury does not show up, no show for that day.
Wow.
Thank you.
How critical a role they play. Who qualifies to be a juror?
So to look at the qualification, let's look at 207, section 207, 205 through to 208 of the Criminal and Other Offences Procedure Act of 1960. So we are looking at people between the ages of 25 and 60 years, resident in Ghana, and who can understand the English language. We are also looking at a person who is not convicted of treason or a felony or of an offense involving dishonesty unless that person has been pardoned. Then we also look at the people who are exempt. So we have a few people who are exempt, even though they may be between the ages of 25 and 60 and are resident and have not been convicted. They can be exempted by reason of the jobs they do. So we are looking at, can I do the exemptions? The president, the vice president, the speaker, and members of parliament are exempt. Court judges of all levels and coroners are exempt. Lawyers in actual practice and other court officers are also exempt. Registered medical practitioners and registered dentists in actual practice, pharmacists in actual practice, prison officers and warders, police officers, members of the armed forces on full pay are also exempt. Public officers other than those engaged in clerical duties, employed in the medical, post and telecommunications, customs and excise and preventive service, or under the Ghana Ports and Harbours Authority. Any person who officiates as a priest or minister of any religion, so pastors, imams, are exempt. Schoolmasters actually engaged in teaching in a school. So the teachers who are actually teachers are exempt. Teachers who work in offices are not exempt. Persons employed in public telegraphic offices as PNT, ECG staff are also exempt. Diplomatic and consular representatives and salaried functionaries of foreign governments are exempt. Editors of daily newspapers. Now, we are not sure about editors of radio and TV.
Okay.
But editors of daily newspapers, because in those days, I'm not even sure whether other than GBC, any other station existed.
The papers were more dominant.
It was just newspapers, and then any other persons exempted by the Chief Justice. So these are the ones who are exempt between 25 and 60, not convicted felons or dishonest people.
Okay. And this is a question I'll ask both of you. I mean, the list is quite extensive. Who are you left with? The pool is very limited.
Yeah, that's the thing. So at the end of
because
the day,
literally everybody is gone.
And at the end of the day, almost everyone is off the list. And that is why we cannot go on with this. When we write to the various institutions to give us jurors, we often would see people who are not really into serious business of the company. And we are looking at more or less clerical staff, cleaners, that kind of thing. And they are not very involved in their workplace, and more or less they are also perceived as people who are quite truant, if I would say so. They are difficult to deal with, so let's get rid of them.
Okay.
And they are the people who come. And by virtue of how they do their things, obviously when they come, they are going to replicate it at our place. And that is why we have not had, over the period, not a very effective system of jury. And so we are trying to expand the list this time to include people from the private sector.
Okay.
And that would include their hierarchy, the most top hierarchy, down to whoever we find useful and who qualifies within the law.
Okay.
And so we are expanding the jury list so that we can be more effective than before.
So you want a wider pool. A wider pool now. Okay. And you talked about how some of the jurors are difficult to deal with. I'm sure absenteeism is one of them. We journalists have consistently, our reporter, legal affairs correspondent Mutala Inusa, tells us about I mean, at a certain point, I think at the latter part of last year, jurors going on strike, definitely affecting, the work of the case that was being prosecuted.
Exactly.
So what kind of measures are in place, for instance, to check juror absenteeism or some of these industrial actions?
So first of all, let's just say that without casting a slur on the jurors, generally, if you had a job as a boss and you were written to and asked to submit people to do jury duty, no boss, no right-thinking boss would give us the one they cannot do without. So they probably will give us the ones they can do without. We are not saying they give us their very worst, but they give us the ones they can do without. So then going forward, what are we intending to do? We are intending to get people who are conscientious. And so this time around, rather than ask them to give us their staff, to nominate people for us, we are going to now ask them to submit their staff list so that we would select from the entire row.
So they give you the entire list?
Yes.
Okay.
Actually, they would receive an order from the court.
Okay.
And that order would indicate that all these institutions are to submit their staff list with their schedules, and then we would obtain, or we would select whoever we want to select to be jurors. Not necessarily the most junior, middle management, or senior. Anyone we think. And then going forward also, there is an intention to apply the law to the letter. Okay. There's nothing new in law which has come in, but what is new for these reforms is the practice direction that Her Ladyship, the Chief Justice, launched in May of last year. If you remember the
Leading Justice.
Exactly. So there is that we are going to apply to the letter. Now, by law, if a juror fails to turn up without lawful excuse, that juror is supposed to be fined, and if the juror neglects or refuses or fails to pay the fine, the person ought to be sentenced to prison for what? 10 days? For 21 days.
Wow.
That is the law. We are just going to apply the law to the letter.
But are they not volunteering?
No, they are not volunteering.
Okay.
They are doing a civic duty by law.
Okay.
It's not like going to vote and choosing whether you want to vote or not. Once you are selected as a juror, you become liable to all the sanctions in the law as they are laid down.
Okay.
Now, if no juror should attempt to go on strike and all that, because it is actually an offense to do that. So once the list is settled, 222, a person commits an offense and is liable on conviction to a fine not exceeding 100 penalty units, who is summoned to attend the court as a juror and does not, without reasonable excuse, duly attend and be present in court and at the times appointed by the court for adjournment, or who is present in court to serve as a juror but refuses without reasonable excuse to serve until discharged by the court. I think that the court should apply the law to the letter.
Okay.
There is no portion of this legislation which talks about any income or remuneration to the jurors. It is just reasonable, I think, that when somebody has spent money attending court, the person should be should have a refund of some sort of their money.
Because it assumes that they would spend money to commute to the court.
Exactly. But even then, let's look at the real situation as it's existed in the last few years. These are jurors who work at ministries. And they are crossing over to the court to come and sit as jurors. So they would have come to work anyway. They would have. So that is, but then even that aside, we should have it in mind that we were having the incongruous situation of having jurors come in, attend, sign their attendance sheets, but there are 6 of them, and so they cannot sit. But they would have come in and signed the attendance sheet, which would be the basis for the payment of money. Now, in ordinary life, we are all men and women of the world. When we attend a meeting and there's no quorum, for which reason we are not able to have the meeting, does anybody ever get paid a sitting allowance for attending a meeting where there's no quorum?
No.
So why would we spend money paying jurors who came to the building and did not actually sit? Or because in those days the jury pool was so small, what we were doing was having the jurors being involved in several cases at once, and so they would come to my sister's court and they would be there for half an hour or an hour, and then another judge would meet them, they'll move, or else, in the end, we would have them in the premises from morning until afternoon, and they would actually not have sat to hear a case, but would still be liable to pay them.
And that is what, our colleague Mutala, at a point, talked about it and how it was becoming a challenge of people being career jurors.
Exactly. Some of them had been jurors 10 years, 15 years. Now remember, we are looking at people who are supposed to be a clean slate, who don't think the way lawyers do, but are sitting as ordinary members of the society, whose perspective should be that different from that of lawyers and judges. But if the person, legal training kind of rubs off on
there are people who learn the law through apprenticeship. So
exactly.
if you do it for 15 years,
you are just as good as an apprentice.
Absolutely.
Because there were actually the old lawyers, and there were lawyers, people who became chief justices who were only apprentices to lawyers. And even the clerks, once they have sat in a court for a certain length of time, they have a fair idea where the court is going. So we cannot have jurors who would come in and for 10 years and so on. That wasn't the situation when we were first lawyers. 20, 30 years ago, it wasn't like that. We would have
That's a long time ago.
Yeah, I don't like saying it, makes me look old.
Oh no, you don't. None of you do look old. We are doing an amazing job.
We are trying very hard. What would happen then would be for us to make sure we have a very large pool. None of them would appear in more than one case at a time. None of them would be in any court, in more than one court at a time. We would also deal with the cases using the method that we have, day to day, all day. We come in the morning, sit all day for 3, 4, 5, whatever number of days. In all cases, no longer than 30 days, as the Chief Justice has directed.
Okay.
And then we are done.
30 days, you say?
No longer than 30 days, maximum.
Some would say that you are sacrificing justice on the altar of speed.
Oh, no. Because now our practice direction or case disclosures is known to everybody, and it's a must. It's mandatory for every judge and lawyers to subject themselves to. As soon as a case is filed, you are obliged to produce, initially I said, give the accused person all the documents that are within your custody that you are going to use against him to prepare his defense. In that manner, the witnesses that are going to testify put all the evidence on paper, which we call witness statements, serve the accused person. We would have done all that. We will meet and then do a case management conference, the lawyers for the defense, prosecution, and then the judges. Then we'll look at what evidence are coming. Then thereafter, we will plan the case schedule that on this particular day, we are starting the trial. And when we start, this particular person is testifying. And so you, the lawyer for the prosecution, this is the witness I have to produce in court. And the accused person also is aware of the witness he's expecting to have his testimony and his lawyer. So the cross-examination would have been prepared already. So there's nothing about it. We are just trying to adjust new ways of doing things so that the society, the public would have confidence in the system again. Because we cannot have one case linger in our courts for 3 good years and the same thing. So they'll come, when the cases of public sensitivity, you see the lawyer, the media is full there. That's what I call them media scavengers. Because if the case is not about public interest thing, you won't see them. But if it's in their interest that there is one story or another about it. But as soon as you begin to do the trial, then you keep them off. We are focused. We are doing the trial. And so therefore, there is nothing outside of what is important. And we will hear the case expeditiously. In any case, as I read the Constitution, that is what is required of the court, to give expeditious trial, fair trial, within reasonable time.
But now, Dedei,
yes,
you see, in addition to all that my sister Lydia has said, it is also important to understand that we are having people who have their day jobs, who have a life. We can't keep them for years. Now that we are also incorporating people in private enterprise, I mean, to tell the truth, it is even an aberration that people in public service felt that they could be in jury duty for those years. Many of them would come to do jury duty, leave after 12 noon or 1 o'clock, knowing that they would have to have closed at 5 p.m., but they wouldn't go back to work.
They'd say they went for jury duty.
They've done jury duty, they wouldn't go back to work. They are supposed to go back to work. They wouldn't go back to work. Everybody also has their job, or their day job. Yet another thing, remembering the presumption of innocence and having someone on trial for that long is rather wrong. The best practice everywhere in the world where jury duty is done is to have these trials from day to day, all day, until the trial is done within a few days. The lawyers who deal with these cases, and even us as judges, we go to places, we learn. Every time I go on holiday, I sit in the Crown Court and follow 1 or 2 cases and just observe how they do their stuff, they do their things, and just realize that no, there are things that we can learn. So wherever I go, whichever country, even if it is just a workshop, but I have a few days, I want to go and sit in court and observe what other people are doing and doing right. But if we have people who are presumed innocent being in court for years, months, it's rather wrong. What should be right is to get it done, and done quickly, so that everybody can move on with their lives.
And do I get the understanding that for some time now the jury has held the justice system to ransom? Oh, I just said, Rosemary said, hey, now Dedei. No, I'm just summarizing.
Well, I can't say so because I also think that if we have been held to ransom, part of it comes from the fact that judges are not going by the law the way they should. Now, being a judge is not a popularity contest, I always say. If one wants to be liked, then you probably won't be effective as a judge. You should just do your job. And the job is that get the jurors to attend. If they do not, find them the way they should be. And if they are not able to pay, put them in custody the way they should be. If the lawyers also fail to show up in court the way they should, the judges are supposed to deal with them the way they should. By rules 98, regulation 98 of the LI 2324, they are supposed to be referred to counsel for discipline. And for the witnesses, they are supposed to attend court when they have been subpoenaed. If they do not attend court when they have been subpoenaed, the court is supposed to either issue a warrant for their arrest or summons for them. And when in my practice, I have issued warrants for the arrest of witnesses who have come in, and I have kept them until their evidence is over. I have referred lawyers to counsel. I have tried people in absentia when they know that they are supposed to be in court and they don't. There are many rules everywhere in the Constitution, in Act 30, which allow for all these things. The problem is maybe people are afraid of what the media will say. They are worried about what Ghanaians will say. I am not the kind. So if anybody wants to go by the law, as it is written, and we abide by it strictly, you would find that the court is very efficient. I have done a trial, presided over a trial, where we have heard altogether 30 witnesses. It was done in 2 years. Somebody else would have a trial, 5 witnesses, 4 years. Why? So all the Chief Justice is seeking to do is to issue directions, which he has done, such that we will all be on the same page. All judges will behave the same. And then maybe we'll have some relief.
Exactly.
And okay, please go ahead.
A case in point is after they returned from their so-called strike. So then I decided I'm not allowing you to pile up any money for you to later, being part of the problem, come and say that we should come and pay you. So if we come and we are not up to the 7 and 6, then either I find the person who has refused to come, and if they intervene, I tell you, all of you lose your allowance for that day. And so we'll go on record that they have sacrificed for their friend, and all of them, they're not going to be paid. So this time, the last time I called the case, I said, okay, if all of you are not up to the 7, I am not going to allow you to record your presence, so that there will be record that you showed up. No, because we didn't work. So sometimes it depends on us, the judges. If we stamp our authority and do the right thing following the law, we will not get a lot of them misbehaving the way they did in the previous region.
So in this approach that you talk about, it means that they will have to be their brother's keeper.
Yes,
you have to ensure
the foreman has to whip them. Sometimes they'll come, where is this person? We have no idea. We put it on the platform that the court at this particular time, but we can't hear from the person. We are not communicating. We are not able to get in touch. So it means you cannot be paid. Now, as part of the reforms, if we don't work, all the 7 don't show up, you all will forfeit your allowance. And I think that is enough to let them be aware that we have to all show up.
Okay, and with regard to the resort to the private enterprises now, does it mean that this time around you won't have, a set of jurors sitting on numerous cases? Is that what this is expected to do?
No. The set that we will get, if we empanel particular jury for a particular case, that is all we would have.
Okay.
We'll deal with that case per that set.
Okay.
And after we are done, we go on to pick another one.
set.
There's
Okay.
a procedure by which we select those who can be coming to doing a particular trial.
Okay.
And so once we are done, we discharge you until such another time that your name shows up. We are not going to show you. And at the same time that we have empaneled you, we are making sure that we are not empaneling you for any other case while this particular one is pending until we are done.
Okay. And how is the selection process done?
Okay.
But just to be clear,
Okay.
we have a pool, and I always use Cape Coast as the example. They have a pool of 150 or 160 jurors.
150 or 60.
Yeah,
Okay. And you
150.
need 7
We only
per
need
case.
7 per
So you can
case.
keep
So,
a
and we
case.
have about 3-4 judges doing the cases. So it means that at any point in time, we'll be needing 28. Now, out of the 28, the rest of them, the 112, whatever, 22 left,
Yes.
will go back to their jobs until the 28 are done with the cases on their table. After which, we would then call the 122 left, plus, if we think necessary, another number of people, so that we'll have a large pool out of which the accused person can ballot. Because we also, with the 160, the names are picked out of a ballot. The accused person has the chance to object to some of them. It is something we teach in criminal procedure.
So it's also a process. They can
yes.
It's a process.
but then there's a limit to the number of rejections.
Yes,
do, right?
there's a limit. 3 without reason.
Okay.
For no reason. So some of them, if it's a rape, for instance, they don't want young ladies. They don't want somebody who looks like a dad, maybe, that kind of thing. I don't know how it works. And then after that, the rest of them, you have to have a reason. So you keep balloting until the accused person is settled in his mind that these are the people I want to preside over my matter, and then we go on from there.
Okay. And I mean, there's pressure on me to let you go because you have to go on television at this point in time. But I wish this would go on and on and on. But one question I need to ask is that what for the jurors to come to a decision, what is the process like after the case is done?
All right, so after the trial, the judge is supposed to give them directions on the law.
What does the direction?
Direction means that, the evidence that is being brought to the courtroom right from the beginning of the trial, the judge tells them, this is what you are supposed to be looking at. Look at the evidence of the witnesses that will be coming, the exhibits and everything that will be produced before the court. Outside of the courtroom, there's no evidence. So anything you hear about the case from radio, on TV, on papers and everything, does not form part of it. And so after the trial, then the judge is obliged to tell them the honors, the burden on who it is that is to establish who is guilty, and then tell them what the law is, what the elements of the crime is, and then remind them again of the evidence, the oral testimonies and the witness, the exhibits, and thereafter put all together. So if we compare, if the law is like this and the evidence is like this, you are supposed to be looking at this thing. And so if you give them directions, they are supposed to return a verdict that is reflective of the evidence that was produced in court.
And in terms of the direction, I have read in storybooks, for instance, where they say that a case, for instance, they can go for file for a mistrial because they believe that the judge misdirected. What does that mean?
You see, in giving the summing up, the judge is supposed to make sure that the directions on law are right. Now, if the judge fails to direct, there are different kinds of misdirection. Misdirection by non-direction, that is maybe in a murder, you did not take the time to direct them that if you don't find the kind of intention and deliberation for which reason maybe you think it's not murder, but you find something which is something like an overreaction, which would then deal with manslaughter, then you do it. And then if the judge fails to direct them on these things, then it could be a misdirection by non-direction. But then also sometimes they do not direct well, maybe it's not detailed enough. The summing up does not give them enough for them to deliberate on. That makes the summing up kind of skewed, and therefore the verdict would be unfair. Remember that in giving the verdict, the jurors never have to give a reason. All they have to do is to give the verdict and indicate guilty, not guilty, whatever, and that's it. No reasons. So we are the ones who are supposed to have given them enough to have deliberated on, such that their verdict would be right.
There's a question that's coming. This is the final one. It says here, please ask Her Ladyship for me that if a judge is sitting on a murder case and the judge has been promoted to another court, will the new judge who will come and replace the old judge start everything afresh? I mean, empaneling a new jury, doing new case management, etc.?
It depends on what the judge's warrants are.
Okay.
First of all, the Chief Justice may give a warrant to the judge who is already presiding to go and finish. So we all sit in the High Court even now. Then also we might, there has been a recent decision of the Supreme Court, maybe 2 years ago, a year ago, which indicates that the judges do not have to start afresh. But because the jurors are lay people, if they have one person dying or some way falling short, the case would have to be tried afresh. But if it is only the judge who has changed, because the judge has legal training, the judge would continue looking at the evidence and the record. But then let's also remember, we are calling for law reform, and every opportunity we get it. Because in other jurisdictions, they also have what is called an alternate juror, where instead of empaneling 7, they empanel 7 plus 2. And the 2 would be like backup. In the event that there is a problem, one of them would step in, because the person would also have sat in the proceedings and gone through it. So that person would be a reserve who can actually take part. So we are asking for law reform. We are also looking at the exemptions. We are thinking that there should be law reform to deal with some of the exemptions, because a lot has changed in 60 years.
All right. Thank you so much. Her Ladyship Justice Ifya Serwah Asare-Botwe, Justice of the Court of Appeal, and then Her Ladyship Justice Lydia Osei Marfo, Justice of the Court of Appeal. Thank you so much. I have been reading our court stories, which says the case presided over by Justice A, Justice B, and then today I get the opportunity to sit with them directly, and it's a rare privilege I do not take for granted. And keep serving Mother Ghana. We appreciate you. Thank you.
Thank you.
I'm enjoying the fact that it's an all-woman panel. So
I agree.
Thank you. And it's International Women's Month too. So
yes, it makes sense, doesn't it?
Absolutely. Thank you so much once again for joining us in the studio. So there's a lot more